Jefferson County Court Law number 2 is now in session. Our first case is Ryan Forrest Farrell. We have Mr. Farrell who is present in court. Mr. Farrell, is your full name Ryan Forrest Farrell?
Yes, sir.
How you doing, Mr. Farrell?
I'm doing good. How are you?
I'm doing fine. Mr. Farrell, you're here represented by your attorney, Attorney Kevin Lane. Attorney Lane, how are you doing?
I'm fine.
State is represented by Attorney Kathleen Nelson. Attorney Nelson, how are you doing?
I'm doing well, Your Honor.
And the probation office is represented by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Very well, sir. Thank you.
The court, this case is on the court's motion to revoke probation docket. Ms. Gilliam and Ms. Nelson, do y'all have a recommendation?
Yes, sir, Your Honor. We'd like to reset for 60 days. We've had a meeting prior to court, and he agrees he can have everything completed in 60 days.
Okay. Is that the group? Okay. Give us a reset.
7-1.
Okay, this case is going to be reset to July 1st of 2022. Mr. Farrell, to give you an opportunity to complete everything you need to complete on your probation. Your attorney is going to get your reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. Mr. Lane, this is your only case. You're free to go as well and you have a blessed day.
Thank you, sir.
Let's see. Mr. Lawrence Klein is not here yet.
No, my client's on the way, Your Honor.
Okay, we'll
For
hold up.
some reason, his name's not coming up on the, he's on the docket for today, but for some reason, his name's not coming up over here. I guess I need to show this to Trina or someone, see if she can get it.
Oh.
Good
And
morning.
let's see, Mr. Cobb Klein is not here either.
I tabbed my name and board number.
This is Lawrence's client right here.
Oh, Jack Lawrence? Okay. Okay.
Are you recording?
Okay.
Okay, he's here. Okay.
What do we? You're okay.
You're okay.
I just did that. Now that just messes up.
You know, I may have.
How's James doing? Is he good?
Yeah.
I have a couple of pro sales.
Okay.
On,
hold on,
MTRP.
okay, hold on a minute. Oh, this is call number 327-274. Case is filed of State of Texas versus, is that Maculus?
Yes, sir.
Laney Toller? Mr. Toller, how are you doing?
How are you, sir?
I'm doing fine. Thanks for asking, Mr. Toller. The state is represented by Attorney Tommy Coleman. Attorney Coleman, how are you doing?
Doing good, John.
That's good. Mr. Toller, I see the last time your case was set, it was reset to give you an opportunity to hire an attorney, is that correct?
Yes, sir.
Have you hired your attorney?
No, sir. Financial wise, I wasn't ready to hire one.
Okay, now, Mr. Toller, you have three options. And I think we had, you print off his judge's explanation of rights to defend this without attorney. Mr. Toller, let me get this to you. This is the document that you, is that a document that you had filled out last time you was here at court?
Correct.
Now, you, on that document, it states that you have three options regarding you getting an attorney. One, you can hire an attorney, or two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you, or three, you may represent yourself.
Yes, sir.
Okay. And it further states that if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. And at the bottom of that document, it has the choices that you can make. One choice is, the first choice is, I want to reset this case to hire my own attorney. That's your choice, and that's the choice you made the first time. And you put your initials on the first line to the left, and you have not hired an attorney. Now, the next choice that you can make on line 3 says, I want to apply for court-appointed counsel. That's your choice. Then you would have to fill out the financial questionnaire for the court to determine whether or not you qualify for an appointment of a court-appointed attorney. Or the last choice, which is choice number 5, if you want to waive your right to an attorney and represent yourself, you can do that. And of course, once you make your decision, you'll sign the bottom where it says defendant, and you initial date, you will sign today's date, which is May 13 of 2022. Okay, do you understand?
Yes, sir.
Okay. Now, what's your choice?
Want to apply for appointment counsel.
Okay, we're gonna give him the judge's explanation and a financial affidavit. The bailiff is getting you a clipboard. You can have a seat. Once you get the information, you'll have a seat. They're gonna give you a pen as well. You can fill it out, and once you finish, we're gonna call you back up and go over the form. You're gonna have a seat out there in one of the chairs that have the black and yellow tape. He's right there. I think he has his paperwork with him. Jaquarin Martez O'Neill Bradley. It's on the motion to revoke probation docket. And this is a motion to revoke probation. You have this, a motion to revoke. Mr. Bradley, have you been here before on your motion to revoke probation, or is this your first time? Okay, now, Mr. Bradley, I have before me a motion to revoke your unadjudicated probation. This motion alleges that in County Code Law Number 2, Jefferson County, Texas, on October 1st of 2019, that the court found the evidence sufficient beyond a reasonable doubt to support a finding of guilt for the offense of possession of marijuana, which is a Class B misdemeanor. The court deferred adjudicating your guilt and placed you on unadjudicated probation for 6 months. The state filed the motion to revoke your unadjudicated probation on June 18 of 2020. In this motion, it alleges, well, there are 3 allegations. One allegation says you failed to pay, another allegation says you failed to perform community service. And the third allegation says that you failed to attend and complete the drug education program. Now, if the court finds any one of these allegations to be true, your unadjudicated probation can be revoked. And if your unadjudicated probation is revoked, the court can give you up to 6 months in the Jefferson County Jail for this offense. Now, you have before you, do you have before you a judge's explanation of rights? Hold on a minute. Let me, I'm gonna go over this with you. Yes, okay. The document that you have before you, Mr. Bradley, is titled Judge's Explanation of Rights to Defendants Without Attorney. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option?
Yes.
Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
And number 3, you may represent yourself. Do you understand that option? Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place the initials on your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Once you have finished placing your initials on one of the 5 lines, then you will sign on the line that's titled defendant, and you will place the day's date, May 13th, 2022, on the line that's titled date. Do you understand?
Yes, sir.
Okay, you could go ahead and take your time and make your choice. You have to make a choice as to,
I'm gonna hire attorney.
okay. Make sure you sign it. Okay, you're gonna stand on the X in front of our,
Green.
gonna stand on the X in front of the court coordinator. She's going to reset your case. Once your case is reset, you'll be free to go and you have a blessed day. Yeah, Mr. Porter. Ryan Eldred Carter. Mr. Carter, is that your full name?
Yes, sir.
Okay, Mr. Carter. Oh, let me do this here. Mr. Bradley,
Yes, sir.
would you please raise your right hand? Is everything, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Now, is everything in that document that's titled Judge's Explanation of Rights to Defendants without an attorney true and correct to the best of your knowledge? That document that you just signed, is
Oh,
every,
yes, sir.
you read the document, you understand everything that you
Yes,
read?
sir.
Okay, you may put your hand down. Okay. Now, your full name is Ryan Elder Carter. Mr. Carter, would you please raise your right hand? Mr. Carter, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Carter, I have before me a motion to revoke probation. This motion alleges that on January 6th of 2021, while you were in County Court at Law Number 2, that you were found guilty for the offense of evading arrest detention, and your punishment was assessed at 180 days confinement in the Jefferson County Jail, a fine of $800. And your confinement was probated for a period of 18 months. On March 3rd of 2022, the state filed a motion to revoke your probation. In this motion, there are four allegations. First allegation alleged that you committed an offense of evading arrest, detention with previous convictions. The third allegation alleged that you committed the offense of unauthorized use of a motor vehicle. The third allegation, the second allegation alleged that you committed the offense of unauthorized use of a motor vehicle. The third allegation alleged that you failed to pay court assessed fees as ordered. And the fourth allegation alleged that you failed to perform community service as directed. Now, Mr. Carter, if the court finds that you have violated your probation, the court can assess punishment up to 180 days in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, Mr. Carter, as a defendant, you have a right to have an attorney. The document that has just been handed out to you is Judge's Explanation of Rights to Defendants Without an Attorney. And I will go over this document with you. It states, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
Number three, you may represent yourself. Do you understand that option?
Yes, sir.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document is titled, well, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed counsel, Then you put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign on the line that's titled defendant, and you will place today's date, May 13th, 2022, on the line that's titled date. Do you understand?
Yes, sir.
Okay, would you like to make your choice? Okay, Mr. Carter. Okay, you want to apply for court-appointed counsel? Okay. The bailiff is going to give you a document that is titled financial affidavit and a clipboard and a pen. Once you finish, you'll be seated to fill that document out. Once you finish filling that document out, we'll call you back up. Okay, just wait. He's gonna go get the clipboard and the form. Mr. Vasquez, you here on it?
Mr. Ashworth, Your Honor, Mr.
Oh.
Bacon's client.
Okay, Ashford did not answer.
He's here, Your Honor.
Well, he is?
Yes, sir, we just signed up. He's waiting outside.
Oh.
We're
Okay,
in the process of working it.
okay, thanks.
Ashworth is here also.
Stafford, you come on up. This is cause number 331674, case of style of state of Texas versus Elijah Lee Stafford. Mr. Stafford, is that your full name?
Yes.
How are you doing, Mr. Stafford? You doing good?
Yes, sir. Running late.
Oh, okay. Now, Mr. Stafford, you are here, you're represented by your attorney, Mr. David Grove. Mr. Grove is appearing via Zoom. And I see Mr. Mr. Grove, can you hear me? Okay, Mr. Grove, how are you doing?
Hello, Judge. I'm having computer difficulty today.
Okay.
I'm here now.
All right. Now, Mr. Grove, you're representing Mr. Elijah Lee Stafford. What is your announcement in Mr. Stafford's case?
Judge, I have not received all the discovery, so I'd like a one resetting, probably a month or would be fine.
Okay, give us a date. Okay, this case is going to be reset to June 17th of 2022. Mr. Stafford, you're going to get your reset in court with our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. Grove, your reset will be sent to you. And I think, Mr. Grove, I think this is the only case that you have, so you're free to go and you have a blessed day.
Thank you.
You're welcome. We had anybody else to show? Let's see if Mr. Cobb person, if Adrian Brown showed up.
No response.
Okay. Is that okay? Let's get Mr. is Uh-oh. Having some problems. Okay, it says the wireless is not connected. Try it again.
Could I go back? Could I just look in?
This one is not working. Okay, let me try this one. Thanks. Court is in session in cause number 330139. Case is filed the state of Texas versus Hunter Leland Ashworth. Mr. Ashworth, would you please raise your right hand? Mr. Ashworth, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Ashworth, you may put your hand down. How are you doing, Mr. Ashworth?
I'm good this morning. How are you?
I'm doing fine. Thanks for asking, Mr. Ashworth. Your attorney of record is Attorney James Macon. Attorney Macon is not here this morning. However, standing in for Mr. Macon is Attorney Joe Vasquez. Does Mr. Vasquez have your permission to stand in for Attorney James Macon?
Yes, sir.
Mr. Vasquez, how are you doing?
Good, Your Honor. How about you?
I'm doing fine. Thanks for asking. State is represented by Attorney Kathleen Nelson. Attorney Nelson, how are you doing?
I'm doing fine, thank you, Judge.
That's good. Mr. Ashworth, I have before me a document that is titled information. This document was filed by the Jefferson County District Attorney's Office. This information alleges that on or about April 18 of 2021, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, this information further alleges that prior to the commission of this offense, that you, Hunter Leland Ashworth, on February 16th of 2017, in County Court at Law number 2 of Orange County, Texas, in cause number C108765, and you were convicted of the misdemeanor offense of driving while intoxicated. And that conviction became final before the commission of this offense. Mr. Ashworth, is that true or not true?
Yes, sir. It's true.
Mr. Ashworth, how do you plead to the Class A misdemeanor offense of driving while intoxicated? Second,
No contest.
now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Ashford, I have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Ashford, there are a set of initials, HA, that are placed on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there is a signature above the line that is titled defendant. Mr. Ashford, is this your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, Mr. Ashford, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box check states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Mr. Ashford, I also have before me a document that is titled Discovery Certification. Mr. Ashford, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Ashford, before you signed and initialed these documents that I've just mentioned to you, did your attorney, Mr. Vasquez, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Ashford, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. State, would you like to offer State's Exhibit Number 1 and State's Exhibit Number 2, the probable cause affidavit?
State offers 1 and 2, Your Honor.
No objection, Your Honor. to either of the-
No objections. State's Exhibits 1 and 2 are admitted. Mr. Vasquez, you advised and counsel Mr. Ashford. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Ashford, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
And Attorney Joe Vasquez has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Mr. Ashford, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 1 year probated by 18 months, $1,000 fine, 80 community service requirement, the standard DWI conditions, 3 days jail, and interlock.
Okay. He's attending, he also will be attending the DWI intervention program?
Correct.
Okay.
Judge, I know you recall Mr. Ashford returned from the other day once he got his schedule squared away. And
Okay.
then when he could report to jail.
Okay, 72 hours. Okay, and when does the jail time begin?
February 20, excuse me, May 23rd at 6 p.m.
Is that correct? May 23rd,
Yes, Your
6
Honor.
p.m.
That's correct.
6 p.m.
Judge, we prefer Mr. Coleman's suggestion of home confinement that Could nobody go along with it?
Okay, that's days in jail. Okay, it's 365. Okay. Mr. Ashford, the state is offering that you serve 365 days in jail, in Jefferson County Jail, which is 1 year. However, this 365 days will be probated for 18 months. During the 18-month probationary period, you'll be required to pay a fine of $1,000 plus court costs of $422. The total fine and court cost is $1,422. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is, the total amount that you'll be required to pay each month while you're on probation, is $160 per month. Mr. Ashford, will you be able to pay the $160 per month?
Yes, sir.
You will also be required to perform 80 hours of community service, attend and complete a DWI education class. You'll have an alcohol and drug assessment. You will attend the DWI intervention. You will also install an interlock device on any vehicle that you own or operate. And you will be required to serve 72 hours in the Jefferson County Jail beginning on May 23rd of 2022 at or before 6 p.m. Mr. Ashford, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Ashford, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Ashford, you'll stand on the X next to your attorney and follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Yes, sir. Thank you.
You are, Mr. Vasquez, I think this is your only case.
Yes, sir.
You'll be free to go as well and you have a blessed day.
Thank you. You as well.
You are.
Okay, you go ahead and sign on that pad. You won't be able to see it, but I will, okay?
Mr. Vasquez. This is cause number 33. Oh, have Mr. Vasquez to come back and his client. I forgot to do something. Mr. Smith, could y'all stand to the side for a minute?
Oh, yes, Your
I
Honor.
forgot to. Just, I need to put something on the record. Oh, Mr. Vasquez, in Mr. Hunter Leland Ashford case, cause number 330-139. Forgot to ask, do you waive a record in this case?
Yeah, sure.
Okay, that's it. All right, y'all may be excused.
Don't scare me like that, Judge.
Okay, this is cause number 330-762. The case is South State of Texas versus Juan Jaimez or Juan Manuel Jaimez Jr., is that correct?
Yes,
Mr. Jaimez, how are you doing? I'm doing fine. Now, Mr. Jaimez, you're represented by your attorney, Mr. Bruce Smith. Mr. Smith, how are you doing?
Fine, Your Honor, how are you?
I'm doing fine. Mr. Smith, what's your announcement in Mr. Jaimez case?
Your Honor, we're trying to get this case coordinated with the case out of Orange.
Oh,
They haven't processed it yet, and so I need just some additional time so that I can do the two together.
say, do you have any objections?
Not at all, Judge.
How much time you need? About
Well,
60 days, 90
About
days?
60 days at least, you know.
Okay, let's reset it. Okay, this case is gonna be reset to July 15th of 2022. Mr. Jaimez, your attorney is gonna get your reset. Once you get your reset from your attorney, you'll be free to go on your blessed day. All right. You welcome. Corey and Griffin,
We're present, Your Honor.
you have the paperwork on Griffin? Oh, nobody, oh, she doesn't have the paperwork. Did y'all send it?
It was Griffin.
Y'all gonna,
Have you reviewed it yet? So Griffin.
okay,
Judge, can we put this on recall? please?
okay, we'll put it on record. Just, y'all just have a seat. We'll call you back up.
A response.
Okay, Mr. Cobb. Mr. Bruce Cobb,
Yes, Your Honor.
your Adrian Griffin still haven't shown up yet.
Yes, Your Honor, I have notified the bail bond person and spoke to them, and they're going to try to get him here as soon as possible.
Okay, okay, we still in session. All
Yeah,
right,
Stan Stanley's the bail bond person. I've contacted him, and we spoke about getting him here. So they're going to do what they can.
all right. All right,
Okey-doke.
good. Okay, No, I was gonna pass it on to you. Yeah, why don't you go ahead and give it to me? Thank you. Okay, Mr. Carter, your full name is Ryan Elder Carter, is that correct? Mr. Carter, would you please raise your right hand? Mr. Carter, do you swear firm to tell the truth, the whole truth, nothing but the truth, so help you God? Mr. Carter, you may put your hand down. How are you doing, Mr. Carter? You doing okay? Mr. Carter, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendant Without an Attorney. Mr. Carter, do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state I want to apply for court-appointed attorney? I also have a document before me that's titled Affidavit of Indigence. Mr. Carter, do you recognize this document? And on page 2 of this same document, Mr. Carter, there's a signature on a line that's titled Defendant Signature. Is this your signature? Okay, now, Mr. Carter, before you sign and initial these documents that I've just mentioned to you, did you read the documents? Did you read the documents before you signed them and initial? And did you understand everything that you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Carter, I've read your documents, I've read the affidavit of indigence, and based on your answers in the affidavit of indigence, you meet the eligibility requirements for the appointment of a court-appointed attorney, and your attorney that will be appointed, the attorney that will be appointed to represent you in this case is attorney Ryan Matuska. So Mr. Matuska earlier. Hold on a minute. We'll see. Okay,
He's presumed competent, isn't
let's see, court is back in session in cause number 331-628. Case is filed, the state of Texas versus Jacorian Griffin. Mr. Griffin, is that your full name? Mr. Griffin, would you please raise your right hand? Mr. Griffin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Griffin, you may put your hand down. How are you doing, Mr. Griffin? I'm doing fine. Thanks for asking, Mr. Griffin. You're here represented by your attorney, Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Lawrence, do you waive a record in Mr. Griffin's case?
No, actually, I would prefer to have some form of record if possible. Just a electronic recording if necessary. I've seen you don't have a court report. I prefer to have a record of some kind.
Okay, and when you say the record, some kind of record, and I'm speaking of as a record with a court report. Do you waiver that type of record? The case is
Yes, I can waive the court reporter as long as you've got a recording of some kind.
well, it's recorded on YouTube, right, as we speak.
Oh, fine,
That's-
fine. That's fine.
Okay, now, Mr. Griffin, I have before me a document that has been filed by the Jefferson County District Attorney's Office. This document is titled Information. This information alleges that, on or about October 22nd of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Griffin, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Griffin, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
No, sir.
Is that correct?
Yes, sir.
Now, Mr. Griffin, I also have before me says reflection. I also have before me a document that is titled Misdemeanor Plea Admonishments. Are you was only supposed to check one box on this here.
Well, it's a Class A.
That's why it's classified in the penal code, Class A. It's not classified as a DWI first, Class B.
Should,
So right now you got two conflicting, you're saying it's a Class B and a Class A.
well, I'll just go with Class A because that's what the code states.
Yeah.
So that should be it.
Okay. Now, Mr. Griffin, I have before me a document that is titled Misdemeanor Plea Admonishment. Mr. Griffin, do you recognize this document?
Yes, sir.
Now, this document, it states that this is DWI enhanced, that is a driving while intoxicated, alcohol concentration level of 0.15 or more, and the range of punishment is classified as a Class A misdemeanor. The range of punishment is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000 or both such fine and confinement. Do you understand that?
Yes, sir.
On page 2 of this same document, Mr. Griffin, there are a set of initials, is that JG that's on the line next to a box that's checked no contendere. Mr. Griffin, did you place your initials on this document?
Yes, sir.
On the next page of the same document, Mr. Griffin, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, Mr. Griffin, this document is titled Trial Court Certification to Defendant's Right of Appeal. And Mr. Griffin, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
There's one box that's checked at the top of this document. This box states that this is a plea bargain case and you have no right of appeal. Do you understand that? Do you understand that? Now, do we have the
We informed Mr. Lawrence that it's sitting right there on the calendar.
Oh, that's the second page to that discovery certification.
Correct.
Oh, shoot.
Where's, he has the first page?
Yes, it's here somewhere. Yes, right here.
Okay.
Wait,
Mr. Griffin, I have before me a document that is titled Discovery Certification. Mr. Griffin, do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant? Now, Mr. Griffin, before you sign and initial both of these documents, all of these documents that I have just mentioned to you, did your attorney, Mr. Lawrence, go over these documents with you? You have to speak up.
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 2 and State's Exhibit number 1?
State offers 1 and 2, Your Honor.
Any objection, Mr. Lawrence?
No objection, Your Honor. There is a little something I need to get into with the court about the interlock device.
Okay, my question is, are you objecting to State's Exhibits 1 and 2?
No, not at all, Your Honor.
Okay, all right. No objection, State's Exhibits 1 and 2 are admitted. Mr. Griffin, are you a citizen of the United States?
Yes, sir.
Mr. Lawrence, you've advised and counseled Mr. Griffin.
Yes.
Is there any evidence that he is currently mentally incompetent to stand trial?
None at all, Your Honor.
Mr. Griffin, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yeah.
And has he provided full, effective, and competent legal representation?
Yeah, I guess.
Okay, Mr. Griffin, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. Now, let me do this here. Now, Mr. Griffin, when you said that you looked a little hesitant when I asked you regarding Mr. Lawrence, when I asked regarding Mr. Lawrence, I asked you whether or not he's provided, were you satisfied with his representation and if he's provided full, effective, and competent representation? Okay. Now, would you like to, you looked a little hesitant on it and you were smiling about something. I don't know what that basically was.
I mean, we only talked for like 2 days, so. It's,
Okay, so you think you need more time to talk to your lawyer?
it's not too much I can really just say.
I mean, do you want more time to talk to your attorney about your case?
No, we came to an agreement.
Okay, now, are you satisfied with Mr. Lawrence's services?
It's all right.
Okay, you think he provided full, effective, and competent legal representation? Okay, I mean, you little, yes, I guess. I mean, I can't guess for you. I just need to know yes or no. I mean, this is not we're not trying to put you on the spot or anything. We just want you to express to us what you think about your services. If you think it was ineffective or you know, you and your attorney got a conflict of interest or something,
It
or,
was all right. I can't complain. I can't complain.
okay. Now, Mr. Lawrence, I mean, not Mr. Lawrence, Mr. Griffin, you entered a plea of no contest, is that correct?
Yes, sir.
And your plea was freely and voluntarily given. The paperwork that you signed, you understood what you were signing. Is that correct?
Yes, sir.
And is everything in those documents true and correct to the best of your knowledge?
Yes, sir.
All right. Are you aware of what you've been charged with?
Yes, sir.
And you're pleading no contest to those charges. Is that correct?
Yes, sir.
All right. Now, Mr. Let's see. Okay, Mr. Griffin, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now, State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 180 days in jail, prorated by 1 year,
This one, okay,
500 fine,
okay.
interlock, in
okay.
the standard DW education classes.
And we have a question for you to decide, Judge, about the interlock.
Yeah.
Let's see. You say you have a question for me to decide about the interlock.
Yes. Yeah.
Judge, I advised counsel,
Do we have a plea bargain agreement? Or do we not
Yes,
have a plea
yes,
bargain?
it's just something, if we have a plea bargain agreement, it's something for you to decide about what his duties will be under the agreement. Here's basically the situation. You have to understand the situation. Mr. Griffin works as a server at Buffalo Wild Wings since June 2021, and that's his job. He makes $2.13 an hour. He has 4 children that he's raising with the woman who had the children. But he lives with his grandparents, and he does not have a car. And the way he's been going back and forth to work is by either Uber or Lyft. What I'm saying by this is
What's the issue? If he doesn't have a car?
he doesn't have a car.
Okay,
And there's a question here. How many cars is he going to have to put an interlock on, if any? Because at present, he doesn't have a car. Now, I could understand if he got a car, then he would put an interlock on it. But at present, he has none. And I was surprised when I asked him, as I was trying to ferret this out, as if his grandparents take him to work, and he said, not usually. Usually it's either Uber or Lyft, some sort of taxi service takes him to work. And I don't question what he's telling me. I think he works very hard. And so he has to use a very cheap taxi service like Uber. So I'm puzzled by, does he have any immediate duty if he doesn't own a car or doesn't use a car regularly? Does he have any immediate duty to put an interlock on something that he doesn't have anything of? I mean, it's a circular puzzle for me.
I think, Judge, I'm sorry, to interrupt. I think it's clearer for the state's recommendation clearly is if he has access to a vehicle or owns a vehicle, that requirement should be in place. That's the state's position.
and
Yeah, I
I
mean,
told
okay.
counsel that as well.
Okay,
If he has
Mr.
access.
Okay,
walk-
Mr. Lawrence.
He doesn't have access to anything.
Okay. So, okay, the issue, okay, let me do this here. You'll be required to have an interlock device on any vehicle that you own or operate. Obviously, if you're riding in Uber or Lyft, you're not operating the vehicle, you're a passenger. So there's no duty for you to have an interlock on every Uber or passenger car that you get in. You're not operating it. Any vehicle, that's what we always say, any vehicle that you own or operate. Now, I think, you can look at Article 42A.408, and it clearly states what his duties and responsibilities are. And that's under the Code of Criminal Procedures, okay? 42A.408, use of ignition interlock device. And that's the law on that. And so the court is gonna follow the law. All right. Now, Mr. Porter, the gentleman in the back. Now, Mr. Griffin,
Yes, sir.
the state is offering that you serve 180 days in the Jefferson County Jail. However, that 180 days will be probated for 1 year. That means you'll be on probation. Instead of going to jail for 180 days, you'll be on probation for 1 year, okay? During the 1 year probation, you will be required to pay a fine of $500. Did you make a change, sir?
I did.
Okay. I don't see an interlock on here. Oh, there it is. Okay. You'll be required to pay a fine of $500 plus court costs of $422. Plus, you'll be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. And you'll be required to reimburse the Jefferson County court-appointed attorney's fees of $250. You'll also be required to pay Jefferson County DDA by education class and initial evaluation fee of $125 on the day of the plea. Should the evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $185 per month. Mr. Griffin, will you be able to pay the $185 each month?
Yes, sir.
All right,
Your
Now-
Honor, I believe he's indigent. He only makes $2.13 an hour.
okay, he said he will be able to pay it.
I don't know if he understands what you're asking.
Mr. Griffin, will you be able to pay the $185 each month while you are on probation?
Yes, sir.
You will? All right. Now, Mr. Griffin, you will also be required to perform 50 hours of community service. You'll be required to attend and successfully complete a DW education class, have a drug and alcohol assessment. You'll be required to install an interlock device on any vehicle that you own or operate. You'll also be required to adhere to the other standard terms and conditions of your probation. Mr. Griffin, do you understand the state's offer? And do you think that the state's offer in your case is fair and just?
Honestly, don't think so, but.
No, okay. If you don't think that it's fair and just, the court can give you an opportunity if you want to withdraw your plea of no contest and revisit with your attorney. But the court will give you the opportunity to do that. What do you want to do? You want to go forward on your with this case or not?
Will it affect anything, like if we do decide to go talk?
Anything like that?
No, I can give you, let me do this here. Let me recess this case right now so y'all can go ahead on and talk, okay?
Yes, sir.
All right. So we'll be in